I've had it, right? Than for Judge Arriaga to go ahead and say my name about 8 times. But thank you, good evening to everyone, and thank you very much to the President for inviting me. I am Judge Walker. I am the current presiding judge of the youth part over at 320 J Street. And just want to give a little background of why I fought so hard for the Brooklyn Misdemeanor Veterans Treatment Court. I am a veteran myself, served in the United States Navy proudly for 13 years. And when I was assigned to criminal court, because my entire background was civil litigation, so of course, when I ran for a civil court judge, they rewarded me and put me in criminal court. So, the very first thing I did was run down to Barnes & Noble on Court Street, and I purchased every book I could find on criminal law, and basically took myself and my court attorney back to law school. Because again, I didn't want to make a mistake. I knew how awesome the responsibility was to be able to take someone's liberty away, and I wanted to make sure that the decisions I were making were the right ones. And so, but I flourished there under the tutelage of a lot of great judges. But Judge Arriaga was one of the best. Alternatives to incarceration, that just had me from the beginning. When I saw who was coming before the court, day in and day out, the arrests that were being done, the lives that were being changed, it was important to me to gravitate towards that. Being in the drug treatment courts, being in the alternative to incarceration courts, people who knew that I was a veteran would identify their clients who were veterans and would say, Judge, can we get my client into a veterans court? 9 times out of 10, they did not qualify because they were charged with a misdemeanor. And we didn't have a veterans treatment court that dealt with just misdemeanors. There was only the felony veterans treatment court. So I asked the question, why does a veteran have to commit a more egregious crime just to get services? Isn't that what we're trying to prevent from them getting to that point? And so it was a lot of hard work. Judge Yavinsky, who was the supervising judge at that time, was an extreme momentous help for me, and we pulled it together, and we started the first misdemeanor veterans treatment court in New York State. So it was right here in Brooklyn. So I'm very proud of that. I couldn't think of a better judge to hand it off to. It was bittersweet because I did not want to let it go, but Judge Arriaga took it, and he has done wonders with it. So I really do encourage anyone out there, and please spread the word, because it is such an incredible thing, as Judge Arriaga said, when you see that change in somebody and you've just been giving them the opportunity. We have literally changed lives for the better. So thank you, Judge Arriaga, for all of that. So now to why I'm here. Raise the age. We all know it. It's still in the papers. They talk about it every day. What is Raise the Age? What is it based on? Why was it implemented? Well, Raise the Age refers to a law that was passed by New York State in April 2017. Raise the age, basically, of youth who were treated as adults in the criminal justice system. What the new law basically did, it made a presumption for 16 and 17-year-olds that their cases would more than likely go to family court rather than them stay in criminal court. And obviously we're talking about felony cases at this point, because what it did for misdemeanors, if a 16 or 17-year-old was now just charged with a misdemeanor, that would automatically go to family court. But for the felonies, they would no longer be treated as adults. Now, it doesn't mean it's automatic. There is still a process that it goes by, but the legislature created that presumption that the majority of the cases, the vast majority of the cases, would go to family court. And how does that process happen? Well, once the youth is arrested and they're charged, there is a mandate for the police to reach out to try to find a parent or a guardian. Used to be they didn't have to do that. Used to be they went ahead, they booked the kids and started going from there. Now there's a mandate for them to try to reach a parent or guardian. Sometimes they're unable to do that, but they are instructed that that needs to be done. And once that 16 or 17-year-old is arrested and they're charged, then they come directly to the youth part. Now, if the youth part is not open, because it's open Monday through Friday, we're open every day, 9 to 5, but if the arrest happens or the arraignment needs to happen after business hours, talking about night court or on weekends, they see what's called an accessible magistrate. So all the criminal court judges have to take these extra classes, which enable them to be called what's accessible magistrates. At that point, the arraignment happens, and if the case survives in the, hello, 5 minutes, I know. If the case survives.
Actually, it's my granddaughter.
Oh, speaking of raise the age.
Hold on 1 second. I don't have to call you back. Yeah, say hello. She's excited.
So what I was saying, as far as in the night court or weekend arraignment, the accessible magistrates can remove the cases to family court at that point. That there is that possibility. Sometimes, depending on the type of the case, the ADA who's there may not feel comfortable with removing the case, and they'll ask the case to be adjourned to the very next business day, which is when they will be before the youth part. There's one youth part in every borough, so there's one youth part judge in every borough. And we are the judges who wear basically two hats. We are designated family court judges, as well as usually acting Supreme or Supreme Court justices. This is what enables us to go ahead and kind of toe that line, whereby we can either keep the case in criminal court, or the case can then be removed to family court. Now, sometimes you say, well, why would a case be removed to family court? Well, we look at CPL 722.23, which is based upon removals of adolescent offenders. 16 and 17-year-olds, they created this nomenclature for them, calling them adolescent offenders. And basically what we look for is three factors. Was there a significant physical injury that was caused by the individual? Was there display of a firearm or a shotgun? Or was there some sexual misconduct under the penal law? If none of those three factors exist, that case is what we would call presumptively removable. Or if the people still feel that the case, the facts of the case are so egregious and they want to keep the case still, they can do what's called a motion citing extraordinary circumstances. And there's a 30-day time period from the date of the arraignment to when they get to file that motion. If the case, again, remains in the youth part, we also do what's called a 6-day review. So from the time of the arraignment, we have 6 days in order for the people to present their evidence at that point why the case should remain, if they feel they can meet one of those three prongs. We have what's called an evidentiary hearing. It's called a removal hearing, and I know that's kind of a little bit of a misnomer, because it's not necessarily a hearing which has all the traditional stakes in it. A lot of people want to say that it's sort of like having a hearing where you want to do a suppression hearing. But all it states is that the court has to review the accusatory instrument, which is normally the felony complaint, or if it's an ex-indictment, you're looking at the indictment, and then you take in whatever relevant facts there are. So the relevant facts are whatever the DA would like to recite, and then the rules of evidence are a little bit looser there. So it's not like you're laying a foundation for the evidence, because the court is the finder of the facts and the law. And at that point, you're just looking at preponderance of the evidence as the standard for whether or not the people have met their burden. So again, 51%. So what I encourage, because I know I don't want to take up everybody's time, but what I encourage is that when people want to practice in the youth part, and this is usually a lot more for 18B attorneys who don't normally practice in the part a lot. I know that the Defender Services, Legal Aid, and Brooklyn Defenders, they usually are pretty good at taking their new recruits in and teaching them about the youth part. But there are certain nuances that everyone needs to know, and there are time frames in order to do certain things. And so we don't want you to miss those time frames, and then the case either gets removed or it has to stay because someone didn't do what they were supposed to do. One of the things, though, that we all do in the youth part is we collaborate. It's very important because we see these young people who come before the court. And I always say I look at the young person, I don't necessarily look at the crime. Because I'm trying to figure out how do we change this young person's trajectory so that they do not become a client for life. I say there's a program for everything except for murder. That's the only crime that there's no program for. So attempted murder, all the sex crimes on down, we can find a program and we can try to change that individual's life. So I would really love to come back and do a full CLE on raise the age, because I really just scratched the surface and there's so much more to go into. But I have some of my other learned colleagues who have more important things to say than I do. I just wanted to end off with one thing. Our great administrative judge loves stats. Not him per se, but last year, the youth part in dispositions did 559 dispositions. That was from January to December. There were only 2 judges who broke 300. And everyone else was a little bit lower than that. And this was the pandemic. I don't say that to pat myself on the back. I say that to say what the sheer volume of work and the people that we have. The Brooklyn youth part is the busiest youth part in the state. That's not necessarily a good thing. But again, it's based on the population of what we have. But I will also say that we remove the most amount of cases in the state to family court as well. We have the least amount of trials that have had to happen. And that really lends itself to the spirit of what we're trying to do. Not necessarily trying to try the cases. We're not afraid to do the trials, but it's really about coming to a positive disposition that will satisfy both the victims, because we know there are real life victims here, but also the youth as well. So thank you very much for taking that time out.